Every day in the USA, people find themselves in court.
Number 56, People versus Rebecca Valentine, 24900 FH.
Thank you, Jonathan Emmons again on behalf of the people.
So, Ms. Valentine, the last time we were in court, I believe you requested to represent yourself. I advised you that I didn't think that was a good idea, and I appointed the public defender to represent you to have further conversation. I still think it's a very unwise decision for you to represent yourself. So what are your thoughts on that?
I decline your advice and I will be representing myself, like I said, a bunch of times.
All right. I understand that you said it a bunch of times. Let me offer you again, since if we see each other a bunch of times, let me just let you into my world a little bit, Ms. Valentine's. Okay. So I have a colleague who, just like me, had a defendant that demanded to represent himself. And at each turn, which is what I will do at every single court hearing, is I will remind you of the risks that you face in representing yourself. In that case, she did that, went to trial, the Court of Appeals, then that person appealed the fact that she let him represent himself, and now she got to do the trial over again. So I am concerned about that. And so for every purpose going forward, at a minimum, you're going to continue with the public defender on standby, which means that if there's something you don't understand, they are there to answer that question, and we would provide time and space for you to speak with them. The risk that you have, Ms. Valentine, as I probably would have told you the last time we were here, is that because you are in, and I'm going to put this in air quotes so that you see me do that, because you are in what is called a place of confinement, meaning you are incarcerated, and that is a statutorily defined location, you could face consecutive, not concurrent sentencing. So a lot of times when someone goes to MDOC for more than one offense, that whole time runs at the same time. Both of these charges are pending before you, and if you were convicted of both of them, and it was determined that you committed them in a place of confinement, which is what's being alleged because you're incarcerated, you could have literally each of those sentences tacked on to the end of your current sentence, and then the second one tacked on to the end of that new sentence if you were convicted. So there's a huge risk for you there. I may be boring you because I'm repeating this, but I'm going to repeat it every time I see you because the risks are that high that you need to know that representing yourself is probably not a wise choice. At this point, do you wish to represent yourself?
Yes, and I've been saying that I'm guilty since like the first thing. So that would be nice if you just took that plea and then we moved on with this show.
I was going to ask your opinion, Mr. Emmons. Do you think this witness, do you think that this party is informed enough to enter a plea at this time, or do you want to put an offer on the record if there is one, and then give her an adjournment to think about it? And if she's ready to go at that point, we can enter the plea then.
I mean, I think that she understands that they can run consecutive, and I would say that the maximum punishment, I think, on each of these offenses is a 5-year offense. She knows that. She knows that she's supposed to have an attorney, or that she can't have an attorney, and that she has one on standby. Obviously, that might be difficult for today's purposes.
Is there an offer in this case?
There's not an offer other than for her to plead this charge. I don't know enough about her to kind of consider anything, and I don't have any way to have those communications where as I expressed last time, I thought an attorney could be an advocate for her. I did send her the memorandum, at least to her, to the prison. I don't know if she got it or not, but I also filed it with the court. So I tried to put everything that you have said to the best of my ability in that memorandum. So if you feel that she's been adequately informed, I mean, she does have the right to represent herself. I also concur that I don't think it's the greatest idea.
Well, I mean, just out of caution, because I don't want this reversed or vacated. I mean, I'm gonna give you another month to think about this, Ms. Valentine, but if in a month you come back and you're ready to plead, I will take your plea. So let me explain to you again, just for the second time, you're not a stupid person, but let me reiterate what the prosecutor just said. The prosecutor is not offering you any deal. Sometimes a deal might look like you plead guilty to count one, they dismiss count two. But because the prosecutor doesn't know you, doesn't know your situation, doesn't know anything about you, and there's been no way for the prosecutor to communicate with you prior to this, there's no deal on the table. So you're being charged with 2 counts of assault of a prison employee, each with a maximum of 5 years, and they could be consecutive. So the fact is that could add 10 years to your sentence. I have the public defender on standby. I'm not going to order the public defender to reach out to communicate with you. I'm going to adjourn this out to mid-January. If you want to speak to the public defender, you can send a communication to them. What they would offer you, what Mr. Emmons was implying, is that they knew your situation. Maybe your defense might be, this wasn't my fault. I have no idea. But the fact is they can communicate anything you want them to communicate to the prosecutor, which might then cause the prosecutor to offer you a deal. Don't know what that would be, but it might be less time on the table for you. So all that is just kind of to inform you of where we are today. I'm going to adjourn this also out to January 22nd. At that time, Ms. Valentine, if you have not reached out to the public defender, if you have not reached out to the court or to Mr. Emmons directly, then I will take your plea at that time as you have asked.
Your Honor, if I could have Mr. Feaster put the phone number when you reach that for Ms. Valentine.
No, I would insult your intelligence by pretending like you don't know it wasn't my fault. I'm just gonna plead guilty. I'm not interested in your deals, and I really don't want to hear more words about it.
Well, if you want to talk more, Ms. Valentine, the public defender phone number is 734-222-6970.
All right.
I don't.
So I'll see you back here on the 22nd at 1:30, Ms. Valentine. And at that time, if you want to enter your plea, we will go ahead through the formality of that, and then we'll proceed then to sentence you. Okay?
Sounds good.
All right, you're all set. Thank you.
Number 42, People versus Thomas Meister, 16-846F8.
Your Honor, thank you, Jonathan. On behalf of people again.
Kim Crawford from Legal Services on behalf of Thomas Meister, who is on the Zoom.
All right, Mr. Meister, your name for the record, sir?
Thomas Meister,
All right, and where are you today, sir? Aren't you out of state?
California.
Okay. All right, today is the date and time set by me last week, actually adjourned the motion to set aside the conviction. So here we are. I'll just state for the record again, we were in court last week. I asked Ms. Crawford if she would brief this because at the time I only had a statement from a third party, not a statement from the victim. So Ms. Crawford piped right up in an enthusiastic manner and appropriately enthusiastic that there might be some issue with me even considering a third party statement or whatnot.
Your Honor, may I put that on the record?
What?
Reasons for my
wanna
objection?
repeat what I just said and put that on the record?
No, can I please explain why I object?
Well, in a
To the letter.
moment.
Okay.
I'm just kind of framing this.
Okay, you said enthusiastic, so I really just jumped right in. Sorry.
Well, that's true. Actually, you're bearing that out. I appreciate that. And so what was unbeknownst to us at that time was that the victim was in the courtroom. So the victim herself made a statement in opposition to the relief requested. So I am acutely aware of that statement as it echoed basically the third party statement. And at this time, again, I've had a chance to review your brief, Ms. Crawford. I mean, to sum up my position, and then I'll hear from you and I'll hear from Mr. Emmons, I think it's my call. I think your client meets the eligibility requirements to have the matters expunged. So I think that ultimately, if I make a finding as it relates to what you've briefed and why I should, then I think I can grant the relief requested. There's obviously opposition to this. And so I think in the end, I just have to make this call. But I've had a chance to review what you submitted. So go ahead and be enthusiastic.
Thank you, Your Honor. First of all, I would like to object to the letter written by Lauren Emerson. There's not a lot of procedural rules on expungement, but the statute does say that the victim has a right to notice and to be present at any hearing and to make a statement. She was present at the hearing and she did in fact make a statement. It doesn't say anything about a third party submitting a statement. If that is allowed, I would object on the grounds that it's improper ex parte communication and also that it's irrelevant. Because the court's inquiry turns on two things: whether or not the circumstances and behavior of his post-conviction circumstances and behavior merit an expungement. Nothing in that letter had anything to do with what he has done since the time of his conviction.
Does it help you to know I'm not considering her letter at all? You need to make a record. I'm not considering that. I had read it before the hearing. I can't unread it. And without the victim's statement, I would have granted any relief you are asking for today by striking that and not considering it. But the victim made a statement, so I'm not considering her comments at all.
I appreciate that, Your Honor. Okay, should I now discuss the victim's statement and the way that it should be regarded? Okay,
I mean,
so,
yeah.
No, I'm sorry.
In particular, beyond what you've briefed, yes.
I think I think my brief was pretty comprehensive. One thing I would like to add is that I think there was a bit of a misunderstanding on part of the victim of what an expungement is and what it does. And an expungement is not an exoneration. It is not vacating the conviction. It just makes the conviction non-public. So someone who's had a conviction set aside means they don't have to tick the box saying they've been convicted of a felony when they apply for employment or housing. Mr. Meister does not want to purchase a gun. An expungement will not allow him to restore his Second Amendment rights. The federal government does not recognize expungements, especially in Michigan and also in California. To purchase a gun, it goes through NICS, which is administered by the FBI. So according to NICS, he would still be not eligible to purchase a firearm. So addressing her fear that he is going to somehow purchase a gun and become a danger to the community, I think is unfounded. And further, there's nothing on the record to suggest that he would reoffend. This was his only conviction. He never had any contact with law enforcement either before or after. He did in fact serve in the Marines. He received the Navy Marine Corps Medal for heroism after he saved a drowning child from a river in Japan. This was a terrible low point in his life. He did in fact do something wrong. But since then, he served his probation. The probation officer said he tested negative on all his drug and alcohol tests. He did get health and medical services through the VA. He participated in outpatient substance abuse treatment at New Light from October of 2017 through January of 2018. The lien check they did before discharging did not reveal any new criminal activity, and that he fulfilled all obligations of his probation. And I would like to also add that he wants to go back to work. He lives in Section 8 housing. He's living completely on his VA pension and public assistance. He would be able to get a really high-paying job immediately because there's a lot of jobs in renewable energy. He's certified and he really wants to become a taxpayer. He wants to work. He wants to provide for himself. And that's the reason he wants an expungement.
Okay. So thank you. Mr. Emmons, again, not being general, but being the best we got today.
Wow. Thank you.
I read the Attorney General's letter and there's no opposition to that in their letter. Obviously, you have some experience and the victim in this case did make an impassioned argument. I'm very cognizant of your argument. So do you have anything that you'd like to comment?
Just to kind of updates from last time, my understanding is that I've been told that, as you recall, the victim was around, that she was with child. She has since given that child. She doesn't. He actually represents that, being here and giving that treatment seen everything, had, I think she suggested that was an aggravating factor to kind of result in early labor and delivery for the child. Who at least was, usually I don't have all the most up to date. But this is, you obviously saw and continue to see the impact that it had on her. In response to the brief, and my apologies, I didn't file anything written. The one thing that makes this situation unique is when you consider the impact that Mr. Meister's crimes have had on the community. Unique to this case is the role that she served, the victim, as being a worker at the hospital, and how that took her, this crime took her out of the rotation of being able to help others in the basement. And so we are all at a loss for her services that she could have provided us as a community. I think that's something that the court should be. And beyond that, I think just to kind of clarify, I got the sense that she understood what the set aside is for. And I think her compelling argument that she made to the court was that I don't get to move on from this. And so I don't think that he should be able to either, right? In this kind of sense that, like, as long as why does she get to pretend like it never happened? Because I don't get the luxury of pretending. I think that was the overwhelming message that she was sending. And I think that resounds. In terms of the statutory criteria, I do think that he is statutorily eligible. I think that there's nothing to say that he is ineligible. In general, obviously gave their response, and I think, quite frankly, and I just wanted to share the updates and kind of some other viewpoints in regards to that decision.
Okay. You know, like, I guess the truth is, for all of you sitting there thinking that I'm up here in my black robe and drink Coke and think this is an easy job, like, this is one of those moments where it's kind of not. If you weren't here last week, you know, you got a guy here who's done everything he can to make on what happened. Guilty. He pled guilty or was convicted. I think he pled guilty, but he did everything he needed to do. And then he asked to have his matters expunged, and he is eligible to do that. There's very strict rules about that, and he meets those rules. He meets the guidelines. On the other hand, victim came in, as Mr. Emmons just kind of summarized. She impassioned said, I don't get to get my trauma set aside. I have to live with that every day. So why should he get this conviction? So now we're me sitting here trying to decide what's the right way to go. So all I can do is go back on what I say at every sentencing. The judge in a sentencing considers 4 things in every sentence. Basically, punishment, rehabilitation, protection of society, and deterrence. And so here we have a situation where this was a terrible act. So, it obviously traumatized the victim, clearly. That lasted years, and it's still ongoing. At the same time, that victim, was in the mental health business. I mean, she was working in a mental health or a behavioral health emergency department at the time. The defendant, Mr. Meister, was in as a patient in that emergency department, clearly having his own behavioral health, mental health issues that I don't know, because I wasn't the judge presiding on the case at the time, but I can assume, even though we're not supposed to do that his behavior was a function of his mental state at the time. And so again, if I look at that, meaning if he wasn't I'm going to put in air quotes because I'm not making any comment about his mental health, I don't know, but if he wasn't of sound mind when he did that, he took accountability for him committing the crime. He didn't try to say this was by reason of insanity. He didn't try to say that he was not competent. He took responsibility for this, and he ended up, with the conviction. And so fast forward the number of years that he's required to wait. I mean, I'm speaking to the room, but I'm really speaking to you. You know, he has no other convictions, no other, meeting with the criminal justice system. His attorney just told me very candidly that, he's trying to become a taxpayer, trying to better himself. And this conviction stands in the way. So when I sentence somebody for something, let me just ask Agent Moore, what do I always focus on? Of those four things, what's the biggest one for me? What's the only hope that we have in this? Oh, no, rehabilitation. Right. The only hope that we all have in this is that somebody does what Mr. Meister did and doesn't get back into trouble, doesn't do anything else to anybody, and literally is trying to turn his life around. Otherwise, how do we go on with our job? Agent Moore is exactly correct. That in and of itself provides the protection to our society. I could incarcerate somebody for the rest of their life, and that would protect society, but that doesn't help us on the hope department. That just is a situation that sometimes is necessary. But in this case, Mr. Meister wasn't, and he's now trying to do everything he can. So at this time, I have all of the sympathy in the world for the defendant in her situation, and I'm not making light of the fact that she still suffers from trauma from this. That's something, Mr. Meister, you're just going to have to live with for the rest of your life. But I believe you do meet the statutory criteria, and I believe that it is in the interest of society to go ahead and grant this relief requested. So, sir, if you would raise your right hand to be sworn in, please.
Swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, Mr. Meister. Ms. Crawford's going to have some questions for you. She's already started this, but I'll just give you a preview. Either her last question or my last question will be, tell me in your own words how this is going to help you. But she started that path, but I'm going to have you go ahead and ask the statutory questions.
Okay, Mr. Meister, first we're gonna put the proofs on the record. I'm gonna ask you some questions. Have you been convicted of more than 3 felonies?
No.
Have you ever had an assaultive conviction set aside?
No.
Are there any criminal charges currently pending against you?
No.
And would you please tell the court very succinctly why this expungement will help you?
Just so I can get back to work, so I can continue to improve myself, and so I can move on and be a productive member of society instead of just using money for my Section 8, my food stamps and everything like that.
Thank you.
Okay. Mr. Meister, I have had a chance to review the Attorney General response in this file, as well as the Michigan State Police records that were submitted. I do find by your testimony and my review of the file that you are eligible for the relief requested. For the reasons that I articulated on the record, I think you are a candidate for this. I am sorry for the victim in this case, because it is obviously stuck with her in a way that it sounded like it may stick with her the rest of her life. I am sorry for her in that. That's something you have to live with. But I do find that this is the appropriate resolution to this situation, and I believe it's the appropriate response to your petition. So absent any further comment, I will sign the order, and we are.
Gunnar, I did want to suggest that I know whatever might impact your decision on this matter, did go to jury trial on this matter. It wasn't a plea, so there was no taking responsibility other than this is what the jury gave me.
Well, I mean, however, in some respects,
Sure.
going to jury trial is a measure of taking responsibility, because a jury of 12 people did find that he did this. It doesn't sound like there was much question about whether he did this. There was no plea of NGRI or anything like that. Okay, I have signed the order, sir. You are all set.
Thank you.
Thank you.
Thomas, I'll call you.